Welcome everybody to our annual holiday tradition of presenting our favorite things as our monthly webinar. We're going to get started here. Brian is going to be operating our PowerPoint today, and so Brian, if you could go ahead and get us going, that would be great. Oh, we didn't get any sound on that, so hopefully
well, the sound works.
Okay. Well, we don't have to, everybody knows the theme song by now. We've been doing it for a couple of years. So we are always appreciative of Leah Zakari having created a wonderful theme song for us. So today, James and I are hosting our favorite things, which of course are our clients and our attorneys, and I don't want to forget our staff too, but our staff are not presenting today with us, but our attorneys are, and each one of our attorneys will be letting you know what one of their favorite things are, with the exception of a couple of our attorneys who are doing a little bit of a twist on their presentations. Next. As you can see, we recently had our holiday party and we were able to get all of our attorneys together, which was a joyous celebration given the pandemic and the challenges we've all faced and having to be distant apart from one another, and because we have a number of attorneys who work remotely for us. So it was wonderful to get back together as a group. Next, James is going to introduce our first attorney.
Well, Brian is definitely one of my favorite things because I get to work with Brian almost every day and I thoroughly enjoy talking with him, particularly because, as you may know, his legal superpower are his medical skills, which he obtains by osmosis, no, actually through conversation, with his wife, who is a very talented orthopedic surgeon. So Brian has acquired what he calls doctor speak. And we all know in this business what that means. And he can talk to doctors in such a way that lets them know that he knows what they know, what he knows is bullshit sometimes. And that's great. So without further ado, I introduce one of my favorite things, Brian. Slide.
I will also just note that osmosis is a process that only affects water. Passive diffusion is what you're thinking of. But I'm not here to talk about that today. I'm here to talk about something else that's equally nitpicky. M&T reconversion requests. So the law on this is relatively straightforward. We don't just have to provide the claimant with medical treatment. We have to provide them with, transportation to and from, or at least reimburse them for it, and things of that nature. But at the same time, we don't have to provide them anything beyond what's considered reasonable under the circumstances. So realistically, what are we on the hook for? Basically, travel to medical appointments, medical equipment paid out of pocket. So like the potential expensive DME that I know Shannon's going to talk about, hearing aids, stuff like that. And one of the things that you occasionally see is people paying out of pocket for medications. So address them kind of in turn. Travel is to and from medical appointments. That's done at the rate set for management state employees, and it's reimbursable at the automobile travel rate, because there's also a motorcycle travel rate, which I doubt any client would actually be using. There's a subject number for it. I have the link to the the state website if anyone needs that. But it isn't just automobile travel. So if someone takes the bus, it can be reimbursement for the bus. If they have some sort of medical need to take like an Uber or a Lyft, like if you're getting an injection or something, you're under sedation or something like that, then that can be reimbursed as well. But you don't get reimbursement for non-medical stuff. Like you don't get reimbursement for going to hearings or for like going to the pharmacy. But it's also not travel to and from all appointments, because it still has to be reasonable. And the question as to whether it's reasonable is if there's comparable treatment available locally, and the claimant's treatment history, and whether the claimant has submitted sufficient support to show that a good faith effort to find a healthcare provider close to home. So what this means in practical terms, not an uncommon thing. Someone from Buffalo moves to Florida. Does that mean that they can, keep flying back up here to treat and we have to reimburse them for their airfare? Probably not, unless, it's a really specialized service they can't get in their, locality. And even then, they kind of have to show they've actually gone and looked and they actually can't find someone to do it. I mean, if they have, 8 back surgeries, thank you, Dr. Zeidman, and can't find anyone in their locality to even touch their case, then it looks more like they will be able to get some sort of reimbursement for it. And this could be across the country or even across the state. So, I mean, if they're going from, Syracuse to Brooklyn to have a surgery that they could have had in Syracuse, then, they are out of luck. So, in order to reimburse, you need a medical report and, certain things like, hotel stays. Say, for example, they actually, are going and say, okay, I don't get the M&T for the travel. What about the hotel stay? Well, unless you have a medical report saying the hotel stay is medically necessary, then you don't get it. Same thing for the gym. Like, the old special funds days, there used to be a lot of, on the old claims authorizing a gym membership in lieu of PT for a year. Well, in that case, I mean, you're going to the gym, you're not going for treatment, so you don't get anything. There's also lumping the other two together for the non-travel reimbursement because they're less common. You need a medical report. So if the person got a cane and they want reimbursement for the cane, do they have a doctor's report saying they need a cane? If they don't get it. That goes everything from a simple wrist brace to those hot tubs the board is or used to be fond of providing. And they also need a receipt for it. This is more common when you get things like medications. And so, the idea is basically for everything, you need a medical report. We had to have been responsible for the treatment. And if it's something they paid for out of pocket, we need a receipt for it. So with that, I'm going to kick it back over to Melissa, who will be introducing our next presenter.
Thank you, Brian. That was great. So now one of my favorite people is Shannon Mackey, who joined us. It'll be 4 years ago in 2022. Shannon is an incredibly interesting person who's had a wide variety of very fascinating experiences, including living in Russia for a period of time. And Shannon's legal superpower is her ability to see the entirety of a case, even at the last minute. And she can see the entire battlefield. She's got a couple of metaphors going here, kind of like the way Peyton Manning sees a defense. And she also believes that she's frequently underestimated in testimony, which if any of you have spoken to her, she's very sweet. And so I can see how that can happen. And she has been told that claimants will often comment to their attorneys how they hope that a nice attorney is there, that nice attorney is there. And this is especially handy on fraud claims because they assume that when Shannon's chatting with them about the things that they did when they weren't supposed to be doing things, because she's so cordial, that nothing bad is happening to them as a result of their disclosures. So everybody, please welcome Shannon, who is going to talk to us about expensive DME requests.
Hi. So Brian, you can go to the next slide. So it's not really quite DME requests, although people have tried to argue that because these aren't medical equipment, it's not DME, but the board kind of lumped it in there. So really I'm talking about in section 13A that requires that the carrier pays for medical, surgical, optometric, or other attendance or treatment for such period as the nature of the injury or the process of recovery may require. And that other attendance or treatment can basically be anything else. The court and the board has consistently noted that it should be broadly construed to accomplish the economic and humanitarian objects of the workers' compensation law. Brian, can you? So some examples are a generator, a hot tub, an air conditioner, when you have bathroom remodels, car modifications, also home remodels, landscaping remodels. There's a ton of things that can fall under this purview. So go ahead, Brian. There's some easy limits. You do not have to reimburse for basic life requirements common to all people. So for example, a generator where it needs to be for devices provided by the carrier, for a mattress is actually the first rebuttal I ever wrote for the workers' comp back in like 2012. Was we only need to pay for the size required for a mattress for the claimant. They get a twin special mattress with 1,000 magnets, not a queen size special mattress with 1,000 magnets, because sleeping with their wife is not part of their workers' compensation disability. So, you know, there are some limits to it. It doesn't have to be for everything that anyone would need. Go ahead, Brian. So the request, it must be by an authorized medical provider. It doesn't have to be on a specific form. There really is a lot of lack of rules around the specificity for here. So for example, you can have, for a generator for a stroke patient, the doctor stated it was needed for power, lighting, heat, and safety. The wife gave a whole letter that was other reasons that were very compelling as to why it was needed, but it wasn't from the medical doctor. So the board found that it wasn't authorized because the doctor was just asking for basic needs of life, and the wife gave a very good explanation of why. The doctor also hadn't treated the claimant in 6 years, so wasn't credible. The modifications must be reasonable under all of the circumstances, and it is the claimant's burden, and there's the third department case on this, to show that it is reasonable under all of the circumstances and that there aren't other alternative options that would be more reasonable. And the carrier, you can have a medical or professional trade evidence to kind of demonstrate whatever it is you're trying to demonstrate. Go ahead, Brian. How to defend, you don't need a contrary medical opinion. It's not a special service. So even if it comes in on a C4 auth, the denial doesn't have to be on that. You can get contrary medical evidence. The first thing I would suggest you do is either contact a lawyer or look yourself on Westlaw for that specific request in the past and how the board has handled it, because sometimes they're very specific in saying what they're looking for. Generator has very specific rules. Car modifications have very specific rules. Bathroom remodels have very specific rules. For example, an occupational therapist usually needs to give an opinion with range of motion measurements as to what the claimant can do for a bathroom remodel. You can request additional quotes, and you can request a review by a professional contractor even after it is authorized, but don't sit on it. So in one case, there was 2 years for a whole home generator for a claimant that really didn't need a whole home generator, but 2 years without a response or review was not reasonable and led to the whole thing being authorized, even though it was the same as the prior case I just discussed, where the paraplegic stroke victim did not get the whole home and generator. So don't sit on it. Respond. Even if you file an RFA 2 to respond, saying this is not a reasonable request under all the circumstances, don't just let it sit. Go ahead, Brian. And how to authorize, you need to clearly lay out if there's any upgrades. That'll be the responsibility and who's paying for it. You can do it with a Section 32. You have to clearly lay out ownership if you're going to have a vehicle that can't be transferred after you modify. Be careful of the professional used. Even if the claimant obtains the quotes, even if the claimant is the one supervising the work and you never go to the house, you are responsible for what happens with that contractor. So in one case, the claimant's contractor was terrible, did a terrible job, messed up a whole bunch of stuff. And the claimant, per their agreement, was actually paying for a whole bunch of extra add-ons to make the home more livable and appropriate. And the contractor messed up on those as well. The carrier was found responsible for all of the damage because the contractor was under their care and supervision. They were not responsible for the additional work itself that needed to still be done, but mistakes made in that additional work they were responsible for. Next. And I'm done. Thank you.
James, you're muted.
Yeah, well, thank you, Shannon. I would like to introduce one of my favorite things, Paul Kornacki. Paul's been with the firm. He's closing in on 3 years now, and his superpower is actually part of his story. Paul flipped the script on Star Wars. He went from the dark side to the light side of the Force, and he brought with him 20 years worth of knowledge about all the tips and tricks and bodies that he buried, and he uses it now to defend Western New York's employers. Well, employers all over the state. Paul spends a lot of time working downstate files too. So without further ado, I introduce Jedi Master Paul Kornacki.
Thank you for that introduction, James. And can we have a slide, please, Brian? Thank you. One of my favorite things to discuss are the possible penalties after a finding of a violation of Section 114A of fraud. And I think it's just important to kind of go back over this now because we do spend a lot of time and effort in prosecuting a 114A case. It takes a number of hearings. There's often an added cost of surveillance. These are expensive to prosecute. And then sometimes we see, though, that after 114A is found, I have noticed that judges will spend not much time or just don't give a whole lot of thought into the possible penalty phase. And that can result in sort of a disappointing finish to a case. There are two types of penalties under 114A. There is the first, and this is by statute. The first is the mandatory penalty. And this is a disqualification of awards that the claimant received as a direct result of a false statement or representation. So if the claimant was receiving benefits related to his injury and he makes a material false statement, you can usually sort of pin a specific date to that false statement or that misrepresentation, and that would be the beginning of the period of the mandatory penalty. For example, the state insurance fund often they send questionnaires to the claimant asking just really straightforward, easy questions. Have you worked at all? Or have you had any self-employment? The claimants will often just check no, sign and date. And that date then can be used as the start of the mandatory penalty. Mandatory penalties are just what they are. They are mandatory. The statute requires that these benefits received as a result of misrepresentation be disqualified. And that would include any scheduled loss of use award. There might be circumstances where there's no mandatory penalty. For example, if the claimant is receiving the medical benefits only and didn't apply for indemnity benefits, that would be rare. So the vast majority of these cases do include indemnity benefits. Where indemnity benefits have been paid and are then rescinded, that will usually create an overpayment. And that the overpayment can then be used as a credit against any future payments, if there are any, or the carrier can try to collect that overpayment. The overpayment can also be used as a basis for a criminal charge. So any testimony given by the claimant at a hearing before the board could possibly be used in any criminal prosecution, which should give claimant's attorneys nightmares. The second type of penalty in the statute is the discretionary penalty, and the board or the judge may or may not impose a discretionary penalty. The discretionary penalty can be equal to the mandatory penalty, or it can be a permanent disqualification of indemnity benefits. There's a caveat that says that the permanent disqualification, this is under by case law, that permanent disqualification cannot be disproportionate to the underlying misconduct. So in order to impose a permanent disqualification, a judge has to provide an explanation that the false statement or the omission was egregious or severe, or that there was a lack of mitigating circumstances by the claimant. The discretionary penalty applies only to the instant file. It does not apply to any prior workers' compensation case that the claimant may have, or to any future case. Now, what constitutes egregious or severe? I think certainly lying under oath at a hearing would qualify, or misleading a medical doctor or an IME as to the claimant's degree of disability. The board does take into account any mitigating circumstances, such if English is a second language, claimant may not understand the question on a form, It's possible that the claimant could make a false statement simply by mistake, and these may result in a permanent disqualification penalty not being imposed. This is typically a credibility issue for a judge, and that will usually be upheld. The judge's ruling on credibility will usually be upheld by the board panel. Where the mandatory penalty is found for a short, limited period of time, typically a discretionary penalty will also likely be limited to the same amount of time. So it must be proportionate to the underlying misconduct. When presenting a case for 114A, I just wanted to advise that we should also make an effort to educate the judge as to what we consider what would constitute a mandatory penalty, giving specific dates, and also advising what the discretionary penalty should be. We always argue that the discretionary penalty should be for a permanent disqualification because that is the best outcome. But when the circumstances don't fit, and if there's any question about whether permanent disqualification would be appropriate, then I believe we should always argue in the alternative that the discretionary penalty should be in an amount at least equal to the mandatory penalty. Thank you, and I want to thank Mike Ryan for the use of this sweater, which is made of very fine burlap and it's like a straitjacket. And with that, I'll turn it over to the host. Thank you.
Thank you, Paul. So it's my pleasure today to introduce to you Cassandra Chrisman, or Cassie as we know her. In addition to pro bono activities, which include being the executive chair of Community Veterans Engagement Board of Western New York, Cassie's legal superpower includes the power of transparency, which gives her the ability to see through a claimant's facade in order to obtain justice. So without further ado, Cassie Chrisman is going to present prima facie medical evidence for us. You're on mute, Cassie.
And that happens frequently, but thank you, Melissa, for that introduction. Yes, so as Melissa had indicated, today I am going to be speaking about prima facie medical evidence. It is something that I think is often overlooked because it has a very low threshold. However, there are some important things to know regarding prima facie medical evidence, which we'll get into, which could prevent the case from going anywhere at all right at the outset. So, Brian, if we could. What is prima facie medical evidence? A medical report referencing an injury which includes trauma and illnesses. So this has been strictly interpreted. The injury, trauma, and illnesses, which we'll get into in a couple of slides, is something that the board has been very strict on with regards to finding, not obviously PFME all the time because that is an interlocutory issue. So if the judge does find PFME and it moves to the issue of causal relationship, but when it does get to the issue of causal relationship, the board has been pretty strict on the verbiage used in this section. So prima facie medical evidence is a preliminary threshold determination in a workers' compensation case, generally made to determine whether there is a sufficient basis to proceed with further development of the record. Now, as you all may know, again, this is an extremely low threshold. It is often met. However, that does not mean we should just give it up right off at the bat. I have actually had various occasions where I have had claims shut down at the outset for PFME. Again, it does not stop it from moving forward eventually with proper medical evidence, but there are going to be some times when a claimant may not want to pursue it any further after being told already they don't have sufficient medical evidence. So I don't think that it's something that should be overlooked, and there are some things to know about how to prevent someone from having a finding of PFME. So there is no requirement that such evidence, PFME, draw a causal link between the injury and the claimant's employment, but later development of the record may lead the trier of fact to conclude that there is sufficient evidence to support the claim. Now, I would say that this is more this is going to be a more strategic route sometimes that some attorneys may choose to take. They may allow the PFME to move forward, knowing it is insufficient, knowing that when it comes down to causal relationship, that there's going to be a missing link somewhere to prevent the claimant from actually having sufficient medical evidence of causally related disability or an injury. So sometimes there may be a strategic, a strategy to allowing the PFME to move forward as insufficient. Again, PFME, if it is found, is interlocutory. So once it moves to that next stage, you almost get a bite at the apple again to be able to present that. And if the claimant has not remedied whatever insufficient medical which you've raised for PFME, you may be more successful raising it for the issue of causal relationship, and the board may agree with you if the judge does not. So there are a lot of times where PFME is found, but causal relationship subsequently is not found. So just be aware that there is a different threshold standard to those, and you do kind of get a second bite at the apple when it comes to arguing for causal relationship. Brian, next slide. So this chart has been very handy for me when I'm looking for PFME or causal relationship. It can be found on the Workers' Compensation Board website. It is very easily read, so that I love charts. Charts make things easy for me. So this is going to tell you exactly who can provide an opinion of causal relationship. I would say most oftentimes I see the one that's providing an opinion of causal relationship, which is improper, is going to be the physician's assistant. So oftentimes the physician's assistant will provide an opinion of causal relationship or give a diagnosis to claimant's history. And knowing that the physician's assistant needs to be actively supervised by a physician, then you could prevent that finding of causal relationship or PFME again, because initially you can argue it on the issue of PFME. So the caveat with that being is that there is a section of the workers' compensation law, 13B2, which does make it a little bit more lenient when the claimant is in an emergency care setting or an urgent care setting, where whether it be a physician's assistant, a registered nurse, they have a little bit more flexibility when it comes to these things because the claimant is in an emergency care setting. So you can find more details on that under the workers' compensation law, section 13B. Just be aware that sometimes if a claimant goes to an ER right off the bat and sees a physician's assistant, it may still suffice. So, however, another thing I would like to point out is that you have to be aware when it comes to physician's assistants that they are being actively supervised by a physician. We have had times, and it's a great question to ask when you're cross-examining if PFME is found and you're cross-examining on causal relationship, to ask the doctor who signed the report under the PA whether or not they actually examined the claimant, whether they were in the room, if they reviewed the report, because there is case law regarding active supervision. And we have encountered several times where a doctor will just be on location with the physician's assistant and signing these reports without ever seeing the claimant, without ever reviewing the report itself. He was only on site, and admittedly, we've had doctors actually admit this, that they are only on location and sign off on these reports. That is not active supervision and should not be sufficient for finding a physician or causal relationship or PFME. That one is probably going to have to wait for the PFM or causal relationship, my apologies, because you're going to wind up doing that after the deposition of the doctor to ensure that he was actually not actively supervising the physician's assistant. Brian, next slide. So here is probably I would say the most successful way that I've had with getting PFME thrown out the window is actually a diagnosis of pain. The board has consistently found, and we're going to go back to the terms which are used in the actual regulation, is the injury, trauma, or illness. The board has consistently found that pain is not sufficient for PFME. It's not only not sufficient for PFME, but it's not sufficient for causal relationship. So that's extremely important to keep in mind. Now, there are some cases where the board has found that even with positive physical clinical exam findings, the claimant is exhibiting, palpation or tenderness upon palpation. He has positive findings, but say the patient, and like in this case with Congregation, Macney, Chum, Inc., the claimant is only then diagnosed with back pain. It is not sufficient for PFME. It's not sufficient for causal relationship. So that needs to be brought to the attention of the judge. And there is case law, plenty of case law to support that. Now with Ulster County Correctional Facility, the board had also found that a diagnostic test along with a diagnosis of pain of some sort is still not sufficient. So oftentimes we have people going to their doctor and they will have an x-ray, or not an x-ray, but an MRI of their back. And maybe they come back with positive findings and the doctor diagnoses back pain. It is not sufficient just because they have positive findings in their back and back pain that they actually have some injury, trauma, or illness as specified by the board as a requirement. Now, pain is not always apparent. This is something that it takes a little bit of extra research. If you don't know a diagnosis which is given, don't be afraid to look it up. I do this all the time. It's something as far as cervicalgia. I had no idea what cervicalgia is, but it really is just another term for neck pain. So the doctor might diagnose neck pain, which is going to be extremely obvious, but sometimes if cervicalgia is diagnosed, it might not be so obvious to the judge to know that that's actually synonymous with the term neck pain. And that's something that also should not be found sufficient for a basis for a PFME or causal relationship. Same with lumbago. It is back pain. It is, it might not be the term pain in it, but that is what it means. Also, rule out after a complaint of pain. So we have oftentimes where a claimant will go into the doctor. The doctor doesn't know what's going on. The claimant's making all of these complaints, but the doctor wants to rule out certain diagnoses. So instead of actually diagnosing something, the doctor will write rule out and then a diagnosis. Well, it's important to know that rule out actually just means that it's a potential diagnosis, but not a confirmed diagnosis. And there is case law to support that as well, which I've provided. It's 2021 case law. So it's important to realize that just because you see a term there that might say a back strain and they want to rule it out, that is not a diagnosis. It's a potential diagnosis. The doctor has not actually came to the conclusion that that is the diagnosis for the claimant. So again, this is PFME and causal relationship do go hand in hand. So I would advise that all of these tips and tricks for PFME, if for some reason it's not successful for you and you wind up having to move past that to the issue of causal relationship, don't be afraid to use the same argument, because the threshold for PFME is different than that of causal relationship. And where you're not successful in one, you could very well be successful in another. And as I've already provided, there is case law to support you. So thank you, everyone, and have a great holiday.
And now I get to introduce yet another of my favorite things, Melanie. And I have to say, she listed her superpower as having extrasensory perception for inconsistencies in records. And that is largely due to the fact that Melanie is extremely detailed oriented. But that's sort of like a secondary superpower. That's like Superman saying that, like, he prefers flying over super strength. What is, in fact, her primary superpower is her ability to generate massive loads of work and apparently do many things at once. I've never seen somebody work as hard as Melanie. So without further ado, yet another of my favorite things, Melanie Daly.
Thank you, James. That was very nice. Hi, everyone. I'm going to be discussing overpayments, which is, I'm sure, one of all of our favorite things to discuss. So Section 22 of Workers' Compensation Law, pursuant to that, the board determines the method and go ahead, Brian. The method and manner in which the carrier is to recoup the payments of an overpayment from the future benefits being paid to the claimant. So essentially, the overpayment occurs whether it be a fraud finding that the claimant was, in fact, engaging in activities outside of his limitations or restrictions, and he was issued a mandatory penalty. then you've been paying the claimant for that time, then you get to recoup that in an overpayment. Or in another case where there's an apportionment between several carriers and you've been paying your full amount for that time, and then a prior apportionment date was issued, then you would recoup the overpayment from future awards. The board does not have the authority, however, to decide the method and manner of recoupment when no money is moving to the claimant. So that is to the Supreme Court. You can go ahead, Brian. So same thing however, when a carrier has two files with the same claimant, then the board may order recoupment of an overpayment on one file from the other file. So if you have been paying the claimant on one file and then let's say there's no money moving from that file, then you can recoup it from a different file from the same claimant. Several examples of that are in these cases. One file, the carrier had two separate claims with the claimant. They had been paying on the one file and then they discovered there was an overpayment. So the law judge issued the overpayment recoupment from the other file. So you can go ahead, Brian. So as a result, if you do have several files for the same claimant and there is an issue of an overpayment and there's no money moving in the one file, then we could work to get your recoupment from the file that you have been paying and where future awards are going to be made. So in the case where we make a fraud finding or an apportionment or any other matter where there is an overpayment, then you can take it from your other file. So thank you.
Thank you, Melanie. Appreciate, and Melanie does a fantastic job with our newsletter as well, although you wouldn't know that because she doesn't give herself any credit on the newsletter pages. I'm also extremely happy and pleased to present and introduce you to Neil Diegelman, who's going to be talking about the 15.3W safety valve. Neil's bio on our website looks like a fake advertisement on a dating site because he's almost too good to be true. His pro bono work includes being a foster dad to pit bulls through Queen City Pitties, which I personally admire greatly because I think I would find it very difficult to be a foster mom or dad, well, dad especially, because it's so hard to give those animals up. And so he and his wife are performing really important work. And in addition to that, his legal superpower is the ability to catch fraudsters. So please welcome Neil.
Hi, everybody. Thank you, Melissa, for that wonderful introduction. Brian, next slide. So in 2017, there were a bunch of changes to the worker compensation law. And the one that I'm focusing on here today is 15.3W, among other things, which here allows insurance carriers may assert a credit against the amount of weeks a claimant is awarded for a permanent partial disability. They're LWEC finding, and we know LWEC has caps. So the limits, the credit to the period of temporary disability benefits paid beyond 130 weeks, 2.5 years from the date of accident, applying only to cases with the date of accident following April 9, 2017. There's more requirements, but before we go to the next, it's important. This is an important tool that we now have. If it applies, we get to apply the weeks that we are paying at temporary partial would apply to the LWEC, but there are requirements. Next. Okay, so like I said, carriers trying to assert this, the date of disablement is after April 9, so effectively April 10, 2017. That brings it out, I think, to October, first week of October in 2019. Temporary partial benefits paid beyond 130 weeks following the date of disablement. So this is important because if you have a claimant who has temporary total benefits, that will not count towards the 130 weeks that we're looking for. The only awards that count are temporary partial, which would include tentative rates if they're not litigated. But and then the third requirement for us to assert this is that the claimant has reached maximum medical improvement 130 weeks after the date of disablement. And I always like to look back at the definition. A claimant has reached maximum medical improvement when a claimant has recovered from the injury to the greatest extent that is expected and no further improvement in his or her condition is reasonably expected. The need for palliative or symptomatic treatment does not preclude a finding of maximum medical improvement. That's always important to remember because, we'll look at some of the treating physician reports and think, hey, maybe this person's at maximum medical improvement, but we obviously need medical evidence to say that. And the fourth requirement is, does the safety valve provision apply? Now, this is the safety valve going the other way. This is the claimant's bar to prevent the application of us taking the credit. Next. So again, this is used to prevent carriers from taking a credit. So the requirements here, permanency must be at issue at the time the safety valve is raised. 2, claimant has produced medical evidence that they have not reached maximum medical improvement. Carrier afforded the opportunity to obtain an independent medical examination commenting on maximum medical improvement, and then the WCLJ finding that the claimant has not reached maximum medical improvement. So what we have is the counter here. So this would, if all 4 apply, then we don't get the 130 weeks. The valve is not triggered yet. So that's one way that the claimant's bar can defend against the claim that we have. However, next slide. A finding that the claimant is not at maximum medical improvement will not trigger the carrier's credit, like I just said. However, it doesn't stop the counting of the weeks beyond 130 weeks of temporary partial disability benefit. What that means, breaking it down, is if the judge finds that the claimant's not, we raised it, we think we're there, claimant produces evidence that the claimant's not at maximum medical improvement, we litigate, judge says the claimant's not at maximum medical improvement. Fine. We don't like it, but that's fine. But it doesn't stop us from, in the future, when the claimant's at maximum medical improvement, to again raise this safety valve. What I've seen in my research in the early time when this started coming up is claimant's counsel was trying to use it as a defense, like proactively, and that just doesn't fly because it doesn't meet the requirements. So while a finding that the safety valve doesn't apply, it also means that the claimant's not at maximum medical improvement and therefore could still have temporary partial disability weeks that when the claimant is at maximum medical improvement, again, we would be able to take some credit for that. A practice tip, any claim with the date of disablement on or after April 10, 2017 should be flagged to watch for the 130-week benefits paid. Again, it's only the temporary partial, not the temporary total, but I think keeping an eye on a file like that does a few things. First, it obviously keeps an eye on when we can assert the credit. And when we think we're ready to assert the credit, that means we can move to permanency. Let's see if the claimant's reached maximum medical improvement. Of course, we'll get an independent medical examination and see what it says. And if it gives maximum medical improvement, then we go down the road of that, litigation. And then at the time of permanency, generally that's when this would apply, and we would be able to take credit for any temporary partial disability paid after 130 weeks of temporary partial disability being paid. And so again, I think it's something to always remember when you're at a permanency hearing. I remember back in my special fund days, remembering a section 123, the first thing I do is look at the date of accident to see if it would apply. And I find myself doing that now, looking at the date of disablement for this, because I think it's important to be aware of. So in our reports that, you'll see that in there where we mention this safety valve, and in combination generally, we're also recommending, let's see if the claimant's at maximum medical improvement. And that's some of my favorite things. Thank you.
It's James again, and I get to introduce yet another of my favorite things, attorney Alexis Hatton. She is a fierce litigator, and her legal superpower, described by herself, is, quote, she is a human lie detector, and Maury Povich literally has nothing on her. And you know what? I've seen her go after claimants. I've seen her attack claims, and I believe her. So without further ado, Alexis Hatton, one of my favorite things. Take it away, Alexis.
You might be muted if your name is Alexis.
Yes. Hi. So we're going to talk about total industrial disabilities. I know we're getting close here to the time, so mine will go really quickly. Brian, go ahead. So I know this is included as one of my favorite things, but it's probably more accurate to say frustrating because it's where you have a claimant who is permanently partially disabled, but when you combine that with other factors, suddenly they're rendered totally industrially disabled. So you can dodge one bullet and then find yourself on the hook for a total industrial disability nonetheless. I think personally that if you see here, it says, what are the factors? The factors that the board considers when combining with permanent partial disability, the claimant's limited educational background, functional limitations, age, language proficiency, training, work experience. If you note, those are all the same factors that the board considers when considering an LWEC. So I personally believe that a total industrial disability is moot because if you have a loss of wage earning capacity finding less than 100%, you're basically saying that all those factors, when combined with a medical impairment, still does not equal a total industrial disability. I have been slapped down on that by multiple judges. But I would still argue that until I'm blue in the face, a finding of a less than 100% loss of wage earning capacity should automatically mean that there is no total industrial disability because they consider all of the same factors. There's nothing there under other factors that is not considered under LWEC. But note, they can also consider causally related and unrelated injuries and conditions. That can be considered in LWEC too. We don't like to say it, we ignore it, we don't admit that, but the board can consider other unrelated injuries in determining the overall LWEC. It cannot be used in considering the medical impairment, but it can be used in considering the overall LWEC. Go ahead, Brian. So what kind of evidence does the claimant need to prove total industrial disability? And this is, again, one of the frustrating things is that claimant's testimony, the board will consider one or more. So if they're considering one, and one of the types of evidence that they consider is the claimant's testimony, simply having a claimant come in there and testify, oh, I'm rendered totally industrially disabled, could theoretically be enough to establish a total industrial disability. And I unfortunately have seen that happen. That is currently under appeal on one of my cases. I believe we're still waiting on the decision on that. But I would argue that the claimant's testimony has to do a little more than just simply state that the claimant is totally industrially disabled. And here's where you go to work. You can dispute, you can attack the claimant's testimony here like you would the claimant's testimony on LWIC. If the factors are the same, your tactics can be the same. So you would question the claimant regarding essentially what they do during the day, any hobbies, whether, just basically grill them on the same factors you would for loss of wage earning capacity. One of the other forms of evidence is any efforts to secure employment. And here, you would use the same tactics you would for attachment. You would attack their efforts to secure employment. Are they applying for jobs that are that they're trained for? Are they making reasonable efforts to secure employment? Are they working with the board's vocational rehabilitation program, or the Department of Labor rather, the Department of Labor's vocational rehabilitation programs. You can attack the sufficiency of the search itself to prove that the claimant is not totally industrially disabled, or that the claimant hasn't met the burden of proving the claimant is totally industrially disabled. Remember, it is not our burden to prove that the claimant is not, rather it's the claimant's burden to prove that the claimant is totally industrially disabled. The other piece of evidence is medical evidence showing that the claimant is functionally incapable of working. Again, I think your job here for the most part is done, because if you get to this point, it mandates a finding of a less than 100% loss of wage earning capacity. So you've already fought off any medical evidence showing that the claimant is totally disabled. So here, for the most part, the only thing that could be new here is some outside disability, like maybe a heart condition or something like that. But again, you would attack that medical evidence the same way you would any other medical evidence. And then the last piece of evidence is a report from a vocational rehabilitation expert. And again, the claimant has the burden of proving that. So the claimant comes in with a vocational rehab expert, you can get your own. So you'll have dueling vocational rehabilitation experts fighting about whether or not the claimant is employable. And usually our vocational rehabilitation experts are very good at this. They'll not only go out and say that the claimant is employable, they'll go out there and find jobs that the claimant could actually be hired on that day. I've seen them come in with job offers for claimants based on the claimant's resumes and things like that. So you can go out and engage those services. But that's pretty much all I have. Thank you, Brian. You can go ahead to the next slide. Happy holidays, everybody. I went through all that already.
Thank you, Alexis. That was great. Alexis had to dash off to a hearing. So now I'd like to introduce you to another one of our favorite things, which would be Katrina Gray. Katrina comes to us also from the dark side, as James characterizes it. And not surprisingly, she is going to be talking about a medical issue today, arthroscopy fun facts, because Katrina's superpower is absolutely diving into medical issues deeply. She does a ton of research on Google and looks up articles and studies in order to be able to refute physician's recommendation with respect to treatment. So not surprisingly, one of her favorite things was a win where she obtained a fraud finding with a mandatory and discretionary penalty as a result of a misrepresentation of a medical condition. So please help me in welcoming Katrina.
Thank you. Okay, so one of my favorite things to do, I'm actually going to admit it, is actually looking through the medical. It's something that I actually enjoy. It isn't just part of my job. And in the workers' comp realm, obviously orthopedic injury claims, especially, we see a lot of medical records and issues associated with arthroscopic surgeries. Now, going through the records, I used to see references to arthroscopies and not really know much about them. But as with most medical conditions and procedures, the more we understand what they're meant for and what are considered reasonable and credible recovery times by the medical community in general, the more effectively we may be able to defend our positions on, for example, whether a need for any procedure is causally related, or as it relates to our position on degree after an arthroscopic procedure, when it seems like the claimant should have been recovered by then. Arthroscopies are indicated for numerous joints, but today I just want to go over some very quick facts about shoulder arthroscopy particularly. Essentially, an arthroscope is a tiny camera inserted into the joint for the doctor to help to be able to see what they are doing during the procedure. Arthroscopy can often be performed on an outpatient basis, with the claimant able to return home that day. It usually has the advantage of smaller incisions, quicker recovery times, and than the traditional open type of surgeries. Next slide. Actually, probably 2 slides, Brian. Yeah. And there are the great variety of reasons to get a shoulder arthroscopy. They include evaluation of the claimant's symptoms to simply see what's going on in there, which may not be showing up on imagery. to do surgical repair of a torn rotator cuff or labrum or some other type of surgical repair, to address shoulder stiffness, to remove potential loose bodies that are in there causing issues. It can also be done for debridement of the joint, essentially cleaning it up in there, or to drain an infection. Next slide, please. Now, arthroscopy for rotator cuff tears, we see this all the time in the records. They're extremely common, with over 3 million performed per year. Often, if the rotator cuff tear is only a partial tear, it can be healed with conservative treatment. But for full thickness tears, arthroscopic surgery is more likely to be indicated. And I really feel that as defense counsel, I think it's really important to realize what the specific reason for the arthroscopy was, because it makes a huge difference in what can be considered a reasonable expectation for recovery time afterwards. For example, if the arthroscopy of the shoulder was just done for debridement or for diagnostic purposes, the recovery time should be much shorter, and the procedure should not reasonably be expected to cause significant limitations in range of motion long term, which is, I think, it's really important when you're arguing that that it's ridiculous that a treating provider is still saying 100% if it's been a long time after a pretty simple arthroscopic surgery, or that the range of motion is significantly impaired. Anyway, any arthroscopy which involves a surgical repair or is more complex can take longer to recover from. As I said, generally the recovery time for our shoulder arthroscopy was considered generally for the simple ones about 6 to 8 weeks, with the more complex type procedures possibly taking up to a year. Usually there are no complications that occur during or from shoulder arthroscopy, but they are possible. Most are minor and treatable. Some of the possibilities for complications can involve infection, excessive bleeding, blood clots, damage to the nerves or blood vessels. And as expected, any complications from a causally related procedure can potentially involve more compensable treatment and or lost time for the consequential injuries or condition of the complication. Now, frozen shoulder or adhesive capsulitis can also be a complication of arthroscopy. This occurs sometimes as a result of the procedure because of the long immobilization period of the shoulder in a sling afterwards, or it can occur from inflammation in the area. I think it's interesting to note that diabetes is actually considered a condition which predisposes a person to frozen shoulder after arthroscopy. And I think it's really good for us to recognize while defending a claim for a consequential frozen shoulder, since it's possible that if the claimant had diabetes, we can at least try to make the argument that the diabetes is partially responsible for the frozen shoulder as an idiopathic condition. And that's it for my shoulder arthroscopy facts for today, and happy holidays, everybody. Thank you.
Thank you, Katrina. And I'm going to introduce another of my favorite things, Brendan Shannon. Brendan is one of our newest associates, but he has already proven to be a formidable attorney. He's been with us for 11 months, but actually quite a bit of that was his time as a law clerk. Now admitted to practice. His legal superpower is, and I can tell you this, he's extremely thorough, and his writing is very good. And without further ado, I present Brendan Shannon.
Brian, I'm not hearing sound. Or Kelsey. Yeah, I think it's an issue of we've always had an issue with this, with playing recorded sound. So thank you. Unfortunately, we'll have to work on hopefully fixing Brendan's presentation for our recorded version of this webinar. Perhaps we'll be able to append it to the end. So with that, then I will move on to introducing another one of our favorite things, even though he doesn't apparently have the Christmas spirit, because I don't think he's introducing one of his favorite things. I think he's talking about how New York workers' comp is different from his experience in Pennsylvania's workers' comp system, and why this is not his favorite jurisdiction. I love Andrew's superpower as described on our website, which is teleportation. He can jump from one case to the next as the situation calls. That's fantastic. So I'd like to introduce you to Andrew.
Thank you, and bah humbug. This is the place of business. I'm done with favorite things. New York is bad for business. Let's talk about the states that are much better for business when it comes to workers' comp. Next slide, Cratchit. In the state of New York, the employee gets to choose their own healthcare provider, provided that the provider is at least licensed and meets the definition under Section 201. The exception, of course, is if the employer is part of a preferred provider organization. But even then, the employee may seek out treatment outside the organization after 30 days, or the employee may seek initial treatment outside the organization, but the employer is entitled to get the second opinion. So there's really not much control over there. Next slide, Cratchit. In Pennsylvania, for example, the first 90 days, the worker must treat with who the employer designates, and that includes even urgent care centers. In New Jersey, the employer controls treatment the entire time. Now that's more like it. My money, my decision. And either party has the right to get a second opinion at their own expense. Next slide. Permanency SLU awards under Section 15.3. Permanent partial disability when treatment is done in case of disability, partial in character but permanent in quality, and then it sets forth the different awards for arm, leg, hand, etc. And you go down to Part X, it goes into the impairment guidelines, down to Section 5B to non-schedule awards such as the neck and back in the state of New York. Next slide. In Pennsylvania, the system is based on wage loss. So if there is no wage loss, generally speaking, the exception would be an amputation. You're not entitled to anything else. Going back to work is the award. You got a bad shoulder, you got a bad back, too bad. If you can mine coal, you're going back to mining coal. Next slide. Preclusion of reports. This is another pet peeve. In New York, under Section 137, independent medical examinations gives 11 different requirements for an IME doctor. And if they aren't met, you can bet the other side wants to preclude the report. Under matter of Raymond Desamores, if the IME doctor misses 2 different dates, the court lays out the groundwork for why the doctor may be the doctor's report may be precluded. Next slide. In New Jersey, no case resolves without each side getting a report or reports that addresses all issues. If the doctor passes away or retires out of state, the party will be allowed to simply get a new doctor. Note, both sides use IMEs. The treater does not provide reports. And the vast majority of cases settle based on reports without taking doctor's testimony. A testimony is typically in court, so parties work with the doctor and the judge's calendars. And PA preclusion is also extremely rare. Depositions are scheduled based on the doctor's availability and generally cover all issues. Both sides want the deposition to occur. The deposition will be used to authenticate and admit the report on direct examination. Opposing counsel has the opportunity to cross-examination. Next slide. Statute of limitations. Section 25A. In New York, it's 7 bloody years after the date of injury and 3 years after date of last benefits. In PA, it's 3-year statute of limitations for both last payment and for both injury and last payment of compensation. New Jersey, it's a far more reasonable 2-year statute of limitation. Next slide. Temporary partial disability under 615A. To make it simple, if a claimant is totally temporarily disabled, he gets 66 2/3 average weekly wage. If the person is only partially temporarily disabled, the person will get less than their 66 2/3 average weekly wage if claimant has not returned to work. Next slide. Now, in New Jersey and Pennsylvania, there is no temporary partial disability. If you're out of work and the employer cannot accommodate your restrictions, then the worker gets the full temp rate. So finally, in New York, there's a win for old Scrooge. I'm done, back to work, and Ben, you all should go back to work too. Time is money. Goodbye.
That was great.
Yeah, I don't even know. That's quite possibly the best presentation I've ever seen in one of these episodes. Okay, now I'm collecting myself. I want to introduce the last of my favorite things that we'll be presenting today, which is Mary Fran Schnorr. Mary Fran says that her legal superpower is listening carefully. What is in fact her legal power is the fact that for quite a while, Mary Fran has been bloodying the battlefield with her enemies in workers' compensation. She's out there in the trenches, winning cases for employers across all of New York State, including the Scrooge that just presented. And so therefore, without further ado, I give you Mary Fran Schnorr.
Thank you very much, James, for that lovely introduction. One of my favorite things is protracted healing period. And what is that? Next slide, please, Brian. Protracted healing period is the temporary total disability benefits that are paid in addition to the temporary total disability healing payments that are made. So what is the healing period? Next slide, please. At least 90 years ago, when medical treatment wasn't nearly as good as it is now, the legislature decided what would be the normal healing period for a claimant who had an injury. And you can see on this chart what they determined for any injury to a schedulable site, because healing period and protracted healing period only involves schedule loss of use injuries. I've been practicing for about 35 years. I have never had one of the thousands of schedule loss cases I've had that has ever involved PHP to an ear. I've only had about 2 cases involving PHP to an eye. But the extremity injuries, that's a real possibility for a protracted healing period situation. Next slide, please, Brian. Now, the WCB takes a lot of different positions, and everybody knows they can switch their position on a dime. But the latest position appears to be what they indicated in matter of months. And that involved schedules to arms and legs. It involved a lot of issues, actually, Section 28, Genduso issues. But in there, they cite a 1933 case that involved protracted healing period. And I found a case that actually goes back to 1926 on this issue. But they held that as per matter of New York Chiropractic College, healing periods in cases are determined by looking at separate injuries. So if you have a case that only involves a leg and arm, one site of injury, that's easy to determine how totally disabled the person was. But what do you do if you have a case that involves 2 separate injuries? Let's find out. Next slide, please, Brian. So there he is, the poor elf on the shelf. He was at the holiday Christmas party. There was some cheap eggnog with some cheap American whiskey involved, and the elves were up there on the shelf dancing like crazy. Well, the elf fell off. Maybe he was pushed. Maybe somebody paid, maybe some parent paid some other elf to push him off the shelf. In any event, he falls, he breaks his leg, compound fracture, and he also sprains his shoulder. He had been earning $1,200 working for Santa and Grinch Enterprises. And by the way, they're self-insured because no carrier in their right mind would ever insure a company that has a bunch of elves working for it. Next slide, please. So he's out of work for 1.5 years, but the parties agree that only 60 of those weeks are temporary total disability benefits. Based on MOT, you determine what of those 60 temporary total disability benefits are based on the arm and based on the leg. And here, you do that by looking at medical evidence and looking at IME reports. They can provide guidance whether somebody was totally disabled or partially disabled. Let's see what happened to the elk. Next slide, please, Brian. Well, there it is. There's 60 weeks of temp total. The healing period for the arm is 32 weeks and for the leg is 40 weeks. The ELF, represented by the law firm of Dewey, Cheatham, and Howe, of course argues that all 60 weeks of my temporary benefits are a result of my leg injury. Forget that arm injury. That was nothing. Even though he had some arthroscopic surgery, go back to the previous report from Katrina, and that healed fairly well. So they look at it and they say, everybody agrees, 25% schedule of the arm, 25% schedule of the leg. Dewey, Cheatham, and House says, hey, wait, 60 weeks of temp total? That means that he has 20 weeks of protracted healing period, because 20 weeks beyond the healing period for the leg happened to this guy. I want a schedule that totals 170 weeks and a value of an award of $136,000. Now, Santa and Grinch say, no. You are not following the WCB position. Let's take a look at the medical. Yeah, he had a bad break, and there was a compound fracture, and he had surgery, and then he had an infection. But by 45 weeks after that, he was doing pretty good. And that is when they decided to do some minor arthroscopic surgery to the shoulder, because now he could at least get around and walk. So he had 15 weeks following that shoulder surgery. And that totals a total of the 66 temp total weeks. But only 45 of those weeks are due to the leg. So sorry, Elf, and sorry, Dewey, Cheatham, and Howe, you don't get 20 weeks of PHP to add to the 150 weeks of the 25% schedules. You only get 5 weeks. Your total schedule is 155 weeks and $124,000. So the carrier, they're pretty happy. They've just saved $12,000. The claimant, well, he's not too happy, but he got those weeks of PHP. So it's sort of a win-win for everybody. And the best way you can defeat PHP is by looking through medical reports carefully and getting those IME reports. They'll give you an opinion on whether the claimant is truly totally disabled or not. Thank you all very much. Have a wonderful, wonderful holiday season and the happiest and healthiest of 2022.
Well, thank you very much, Mary Fran. I think Melissa's talking, but she's muted. But I will say on behalf of all the attorneys of LOMAD, we want to wish you.
And I would just like a quick opportunity to note that we have hired recently and have recently added additional associates to our staff who will be seeing you in a future webinar. We have hired Bing Huang, Suki Harada, and Michael Roberts, and we're very happy to have them on our team too. And we fully expect that they will be among our favorite things next year.
Well,
ahead,
I just want to finish by wishing all of you out there a very happy and healthy holiday season and a happy and prosperous new year from everyone at LOMAD. And we're looking forward to a great 2022. Happy holidays,
everyone. Happy New Year.